Welcome everyone to our webinar about preparing your business for success in 2025. My name is Thomas Linnane, a lawyer in our tax team, and my co-host is McKee, a practice leader in our commercial contracts team. Before we begin, a couple of quick housekeeping items. You'll receive a recording of the slides in the webinar in your email following the webinar. Please submit your questions in the Q&A box throughout the webinar and we'll answer them at the end. And please complete the feedback survey after the webinar finishes. For the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. Please provide your contact details in the survey at the end of this webinar to claim your complimentary consultation. So today we'll be discussing the following as they relate to preparing your business for success in 2025. Business structuring, having the right contracts in place, protecting your intellectual property, data and privacy obligations, and some key changes to the Australian company law landscape, which we'll wrap up afterwards with answering your questions in the Q&A. So before we move on, we'd love to have you answer this poll question about what your focus is on in 2025. So what are you keen to have your area of business most strengthened in within 2025? So is it choosing the correct structure for business growth, updating your contracts for clients or your team members, protecting your intellectual property, meeting data and privacy obligations, and understanding the key upcoming legal changes? So if you can vote on that poll, that would be fantastic. And we'll talk about that in a bit more detail later. So now I'm going to start by speaking about business structuring. So having the correct business structure in place is important to manage your risk as a business generally, but it's also significantly important when it comes to growing your business. The right structure can be very dependent on your particular business, what stage it's at, the industry in which it operates, and even your personal situation as a founder. And of course, what may be appropriate on day one may no longer be appropriate as you scale. There are many ways that you can choose to structure your business, which includes a sole trader, which is essentially an individual with an Australian business number. This is a pretty easy structure to set up, but exposes the individual behind the business to a lot of personal risk. Then we have our partnership, which is where one or two people are working on a business together with the view of making a profit. Again, this is quite a simple structure to set up, but isn't great from a liability perspective because each partner in the partnership has what we call joint and several liability, which means that each partner is responsible for all the assets and the debts of the business. Then we have a trust, which is a structure whereby an individual or a company acts as a trustee and owns and operates all of the business operations for the benefit of what we call beneficiaries. It is a common structure, but it's not the most tax efficient due to any retained earnings that are kept in the trust at the end of the financial year being taxed at the highest marginal rate. And then finally, we have a company, and there are different types of companies, but the one that we most often see is a private company limited by shares. So before we get into the company specifics, I can see that the poll has ended. It's a pretty even split across some of the areas. It seems like for the most part, though, people were the most keen to learn about the upcoming legal changes across the legal landscape in 2025. So we'll definitely have a chat about those towards the end of the webinar. So thank you for your participation there, guys. So circling back to a company. So it's definitely the one we see the most common, especially for the more fast-growing startups. And that's because a company does come with a lot of benefits that the other business structures don't. So in those benefits include limited liability. And so what that means that if there is ever a claim that's brought against the business, it's brought against the company itself rather than any of the controllers or any of the founders that are sitting behind the company structure, subject to some exceptions. And that's because a company is what we call a separate legal entity. So it has its own legal personality that's distinct from the founders and other owners and directors. It's also quite a flexible structure, so it's easy to expand as you can give equity to key stakeholders such as your employees and your investors by issuing more shares in your company. And it's also quite flexible in changing ownership as well by being able to play around with the directorship pretty easily. When it comes to a company, retained earnings are a lot easier to deal with in a company, meaning you can more easily invest profits back into the business rather than having to distribute it out. There are also certain tax concessions which are only available to companies, such as the research and development tax incentives and the ESIC concessions, which are available to investors. And then on investment, the investment opportunities are just a bit more significant when it comes to companies, because there are more strategies with being able to provide investment to a company, but it's also a more familiar structure for those investors, so they're more likely to invest in a company. So having a company structure gives a business an opportunity to have what we call a group company structure as well. So it's essentially where there's a holding company which owns all of the key assets of the business, and then there's an operating company which is wholly owned by the holding company, which is the entity that trades. So that's really good, especially if you have key assets like intellectual property. By having that dual company structure, you're able to separate out those assets and protect them in the event that there's a claim against the operating company or, unfortunately, the business was to fail. And it also provides flexibility and expansion because you're able to have multiple operating companies which start to make more sense as the business operations start to expand and you want to separate out the business activities of the business into multiple companies. So we really do encourage our clients to continue to assess their business structure and whether it is appropriate for their business, taking into account the current growth and stage of your business, as well as your plans for 2025 and beyond. Of course, having the right structure in place as early as possible is ideal, albeit it's not always the most realistic, and restructuring can be quite an involved process, especially when you do have a lot of shareholders on your cap table. So if you need to restructure, LegalVision can certainly assist with walking you through the corporate law and tax law issues involved. So I'll now hand over to Lauren, who's going to talk about your key commercial contracts.
Thank you so much, Tom. With the new year upon us, now is as good a time as ever to review the contracts you've got in your business, or perhaps the contracts you don't have in your business and need. In terms of running an audit of your business, the contracts you've got, you want to check that they are up to date with how your business operates. We see businesses get contracts drafted once, and then 10 years later, they're running a very different business. So we want to make sure they're up to date with the services or goods that you actually provide. We also want to make sure that they are up to date with current laws. So for example, we have unfair contract laws that have come in place in the last couple of years, and the ACCC can now introduce penalties if you're putting in place unfair contract terms. So we want to make sure that there's no unfair contract terms in those contracts of yours. We also want to make sure that they've got clearly agreed terms, and in this sort of market that we've got at the minute, which is quite uncertain, I suppose, economically, you've got provisions in place that can help you out. So in terms of providing your services or goods, software, whatever it is you're providing, there's a number of key terms which are critical to have in your contract. I suppose something that we're seeing at the minute that is really important is making sure you've got adequate terms in there for you to get paid. Now, with inflation falling, but I guess it's still high, it's important to have rights in your contracts that if they're sort of long-term contracts, that you can increase the price over time, sort of maybe at least annually. A common clause we'll see is that you can increase the price by CPI or perhaps a fixed percentage. So this will give you certainty in those longer-term contracts that the contract will still be valuable for you. In terms of payment terms, these are also super important. Obviously, upfront payment would be best if you can get that. However, that's not always possible. So if you do need to provide sort of ongoing payment terms, or if it's a subscription, your contract should set out really clearly what the customer needs to pay, what happens if they don't pay. So can you suspend your services? Can you charge them interest? Can you go into their business and recover any goods that you've supplied to them? This is basically going to make it a lot easier for you to make sure you get paid and can recover any of those costs. In terms of other key clauses, when you're supplying any goods, services, software, supplying your what it is that your business does, it's always going to be super important to cover those commercials. So how much you want to get paid, what those payment terms are, what the actual services or goods are that you're providing. And then other key clauses will include liability. So making sure that there's a cap on your liability. You're not sort of exposed infinitely You want to make sure that there's adequate and correct clauses in there regarding IP, so who owns that IP, and making sure you retain ownership, at least of that IP that you use for all of your clients and that you need to retain, and making sure you've got termination rights should the other side not pay. Another type of contract that you'll have is with your suppliers. So this is anyone that's providing you with any sorts of goods or services, software. I'm sure there's a whole raft of suppliers that you've got in your business. In terms of what's important to have there, I guess it's similar to your client agreement when you're the one providing services, except there's a few different things that are going to be more important to you this time. Most importantly, you want those goods or services to be provided. You want them to actually be provided. You want them to do a good job. You want things to work. You want the quality to be good. You want it to be done on time. And then in terms of IP, perhaps if someone's creating anything for you, you want to make sure that you own that. And what we're seeing as well is a lot of sort of software contracts. So one of the key things there is making sure that you the software is available. So if it's business critical software and it goes down, so your whole business goes down, that's obviously going to be a huge issue. So making sure that that's dealt with. The last type of contract I wanted to touch on, and it's important to have a look at this at the beginning of every year really, is your employment contracts. So it's essential to ensure that they're compliant with current laws and best practices. They need to comply with the national employment standards and any relevant awards. Your contracts for employment should include clear job descriptions, duties, and performance expectations. And you also need to make sure you're sort of specifying the employment type. So whether that's full-time, part-time, casual, and any sort of hours of work. Now is also a good time at the beginning of the year to make sure all your employee policies are up to date. So I'm talking things about, staff handbooks, anything to do with remote work. Now's a good time to check that they're sort of all in line and up to date with how your business is running. The next thing Tom and I want to discuss today is IP. So I'll let Tom sort of run through that now.
Great, thanks, Lauren. So intellectual property, or IP for short, is an umbrella term which is used to describe a range of legal rights that attach to certain types of information and ideas and to their particular forms or expression. So this could be through a trademark, a patent, or rights in copyright, for example. Having the right type of protection for your intellectual property helps you prevent or stop other people from stealing or copying the names of your products or brands, your inventions, the design or look of your products, the things you write, make, or produce. And so when it comes to intellectual property, you can really break it down between your registrable IP interests and your non-registrable IP interests. So we'll start with the registrable IP interests. So your branding, including your business name and logo, are assets of your business which are really worthwhile protecting. They're really key assets that go to the heart of your business. So with the business name, first and foremost, you should register this as a business name with ASIC. This gives you the legal right to trade as that name, and ASIC does have the right to put fines on you if you don't register that business name but trade under it anyway. You can then further protect your branding assets through the trademark registration process. Having a trademark gives you more rights over that branding as it relates to the goods and services you sell, including but not limited to being able to stop others from using that same branding. The trademark process does take a long time though, up to 12 months depending on the country, so it is best to start this process early. If you have other intellectual property which can be protected through registration, such as a distinct product design or an invention, you should also look into whether these can be protected through design registrations and the patenting process, respectively. You should also do regular checks to ensure that your brands and product lines are cleared for use to avoid infringing on any third-party rights. So even something as simple as a quick Google search or a search of the IP Australia trademark register can go quite a long way in figuring out what other branding is already out there and whether what you're doing is similar enough that it could be considered an infringement of that. And that could save you quite a lot of time and money, particularly if the other party does bring a claim for trademark infringement. Another key point to really be aware of is that trademarks are a country-by-country registration process. So if you do operate in multiple countries by providing your goods and services there, these registrations should be occurring in each country, as having a registration in Australia may not protect you if you're trading in another country and there's a breach of your intellectual property rights there. So while IP registration, such as the trademark and patenting process, is important, so too is the other side, being the non-contractual or non-registerable IP ownership, which I'll talk about now. So not all IP can be protected through registration, which I have canvassed. So examples are things like copyright and your trade secrets. So when you enter into a contract with someone else, depending on the nature of the goods or services that are being provided, new intellectual property may be created when the parties perform their obligations under that contract. So to this end, your contract should contain clauses which detail which party owns the intellectual property which is being used or created throughout the arrangement, both before and after the contract is being entered into. In this regard, a contract should consider ownership rights in respect of the intellectual property owned before the contract has been signed. So does that stay with the original owner, or does that pass as a result of the contract? The intellectual property that is created or developed under the contract, so who owns that? And then finally, any improvements made to a company's pre-existing intellectual property or to the intellectual property created or developed under the contract. So throughout a contract, there may be improvements made to one party's IP. So it's important that the contract deals with who those improvements actually belong to after the contract is over. So you should also consider whether or not you may need a license to use the other party's IP, and whether it would be a good idea to give a license for that other party to use your IP. A common example is you may need to use another party's IP to provide your services, and if so, this license should be documented in the contract. And if you are going to give the other party deliverables, which will include your intellectual property, the other party will need a license so that they can use those deliverables so that they can perform under the contract. So whenever you think about an IP license, the scope of that license is super important. So in drafting a license, you'd need to consider things like whether it's going to be revocable or irrevocable. So will it last forever, or can it be revoked by one of the parties? Is that license transferable? So can the party give that license to someone else? In the same or similar vein, can that party sub-license that license to someone else? So give a license to another party to use your intellectual property or not? Whether or not that license is going to be royalty-free or whether the other party has to pay for it. And this is particularly important, especially when you're dealing with related parties who have intellectual property licenses on a cross-border basis, because there can be particular tax consequences when it comes to cross-border royalties. So that's just something to be super aware of. So how long the license is going to last for? So is it to only last for the term of the agreement, or will it last forever or another specified period of time? And then finally, what's the purpose of the license? Can this person use your intellectual property for whatever they like, or is it going to be limited to being able to provide their services under the contract? So there's just some of the things to think about with IP licenses. And then finally, from me on intellectual property protection, if your business is IP heavy, you should consider how your business structure can assist with protecting your intellectual property. A common business structure, which I canvassed earlier, is a dual company structure. So in this structure, a holding company owns all of the IP and the other key assets of the business, and the holding company will not trade. Instead, the operating company, which is wholly owned by the holding company, will trade and operate the business. So this structure is a common way of separating out the important assets of a business, including IP, from the operational risk of the business, with the idea being that, generally speaking, you can only bring a claim against a party that you have a contract with. And because the contracts will all be at the operating company level, generally the IP sitting up in the holding company would be protected because it doesn't have any contracts. So that's it from me from an IP protection perspective. I'll hand back over to Laura now, who's going to chat you through your data and privacy obligations.
Thank you, Tom. Yes, let's move on to data and privacy now. These are things that are always going to be important and ongoing considerations for your business. In terms of what personal information is, it's essentially information or an opinion about an individual who is reasonably identifiable. Doesn't matter if that information or opinion is true or not, and whether that's recorded in a material. So we're talking here people's names, addresses, email addresses, tax file numbers, passports, all sorts of things, really. The list goes on. Health information, and this is all governed by the Privacy Act. Underneath the Privacy Act, there are 13 Australian privacy principles, and these set out what businesses need to do, when they can collect information, when they can share information, what needs to be in their privacy policy. So it basically has all the rules on of what a business needs to do to comply with the Privacy Act. Now, in Australia at the moment, this could change, but at the moment, not every business needs to comply with the Privacy Act. We've got a small business exemption, essentially. So if your business annually turns over less than $3 million, then you might not need to comply with the Privacy Act or the Australian privacy principles. And the exceptions to that would be if you are providing services under a Commonwealth contract to the government, if you are trading in personal information, so maybe you're selling data, or if you're providing health services. So there's a large section of Australian businesses that won't need to comply with the APPs for the minute, although as I sort of canvassed before, that might change. In Australia, the regulator of privacy is the Office of the Australian Information Commissioner. And in recent times, they've been very busy. They've been quite active in taking action against businesses who are in breach of the APPs. In 2025, they've said that particular areas of focus for them are going to be regulating the online environment and emerging technologies that have a large impact on privacy. So this includes things like facial recognition technology as well as AI. Last year, we saw the OAIC start preparing a lot of guidance papers on AI. So they've got different tools for those that are creating AI products, as well as businesses that want to use AI in their business. So that's quite useful for you. We also saw late last year in November, the OAIC found that Bunnings breached privacy laws by using facial recognition technology in 63 of their stores. They collected sensitive biometric data from hundreds of thousands of individuals without any proper consent or notification. And I think this case really shows that the OAIC is, scrutinizing emerging technologies like AI and facial recognition, and you need to sort of be careful when using those. We've also seen the OAIC cracking down on businesses in the healthcare and AI space. So there's been a number of sort of things that have come out there demanding that if a healthcare business is going to use AI tools in their business, that they should be getting consent to do so. In terms of looking forward in the future, two key pieces of legislation that were tabled last year, not yet law though, that you should be keeping your eye on are some amendments to the Privacy Act, which was under the Privacy and Other Legislation Amendment Bill 2024. Essentially, it aims to strengthen privacy protections, enhance enforcement powers. There honestly wasn't as many changes as expected, but key changes included clarifying information security obligations, streamlining overseas data flows, and requiring enhanced transparency for automated decision-making. As I said, these aren't really groundbreaking. However, we're expecting further changes to come, including with the possibility of removing that small business exemption. So keep your eyes peeled for that. We also saw a bill tabled in the cybersecurity space that will have sort of far-reaching implications for businesses in and outside of Australia, including with sort of encouraging businesses to disclose ransomware attacks and payments. So as I said, these are still both bills, not yet in law, but they may come into law in the future. So good to keep your eye on that. The other thing I've done for you today is I've put together a checklist for you to run a bit of a privacy audit on your business. You'll get these slides after today, which you can run through yourself, I guess. But in terms of some of the key things to have a think about now that we're going into the new year is making sure that your privacy policy is up to date. So it covers the current things your business does, the information it collects, what it uses it for. You've got good consent management in place. This is important for marketing. It's important if you're collecting sensitive information like health information. You've got a good process for cyber incident management. So good relationships between your tech and security teams and your legal or operations teams. And you know what to do if any sort of data breach happens. You've got good staff training in place so that your staff know what to do when any issues arise. So if you've got clients requesting access to their information or any sort of complaints coming through, your staff know what to do. If there is a data breach, that's super important. If you're bringing on board any new technologies, also a good chance to make sure that they run an assessment really to make sure that you're not doing anything that's going to put you in breach of the APPs. You also want to make sure that all of your documents are up to date. So that's your data retention policies, any internal processes, data minimization. So that would be with respect to making sure you're holding information for as long as required under laws so that you can run your business, but also not so long as to breach any privacy laws. And of course, that you're checking that if you're transferring information overseas, that you're doing so in a safe. Now what we'll do is we'll run through some of the changes that we're going to see in the legal landscape coming into 2025, and then we'll answer questions that are coming through. I can see a couple come through, so if you've got more, send them through. Tom, do you want to run through some of the first changes we're seeing this year?
Yeah, absolutely. Thanks, Lauren. So yeah, as we enter 2025, there are several legal changes that will come into effect that will affect businesses. So it's important that you get across these and make sure that your business is ready to comply if they do apply to you. So first one that we're seeing is that there might be updates to buy now, pay later arrangements. So any business that offer these types of arrangements should be aware that there are proposed changes coming to the financial services and regulatory space. So these include that there may be additional requirements to actually offer buy now, pay later services, such as the business offering it having to hold a credit license and doing additional credit checks on the users who participate in the buy now, pay later arrangement. Something else which is, especially in the tax space, which has come up, is that in the wake of the PwC scandal, there has been a big crackdown on tax and BAS agents and their ethical obligations. So starting this year, tax practitioners will be under stricter ethical and operational requirements, and this may affect the information that your accountant or other tax advisor may actually ask you for when they're assisting with your tax affairs. And then on the tax vein, so, in the second half of the 2025 financial year, the ATO has said that it's going to continue its focus on a business's employment tax obligations. So in particular, things like pay-as-you-go withholding, superannuation, and fringe benefits tax. And then also we're seeing a lot that they are cracking down more and more on goods and services tax obligations and making sure that businesses are lodging their business activity statements on time. And then also it seems like the ATO is also taking a closer look at things like where the early stage innovative company concession has been claimed by investors, and also any cross-border dealings between related entities as well. So if your business is in that kind of space, or if you have particularly contractors, but employees as well, it'd be worthwhile getting tax advice to make sure that you are complying with those obligations, because particularly things like pay-as-you-go withholding, super, and goods and services tax are obligations that directors can be made personally liable for if the company doesn't comply with them. So super important. Yeah, I'll flick back to Lauren, who'll talk about some other key updates.
Thanks, Tom. Yeah, we're seeing a couple of changes in the employment landscape as well. So from January 1st, 2025, that's already been and gone. Unintentionally underpaying your employees is going to be, it's a federal crime. So this applies to all businesses, including small businesses, and the penalties can be quite severe. So that includes up to 10 years imprisonment for individuals and fines of up to $8.25 million for companies. To help small businesses comply, the Fair Work Ombudsman has introduced a voluntary small business wage compliance code, which you can take a look at. We've also seen some changes to introductory classifications. So some employment awards have new rules starting in early this year. These classifications, which often allow below minimum wage payments during training periods, will now be limited to a maximum of 6 months in affected awards. From halfway through the year, so August 26, the right to disconnect, which we saw surface last year, is going to extend to small businesses. So employees in all businesses will have the right to refuse work-related contact outside of regular business hours. However, the impact of this law may be limited in businesses with flexible working arrangements. The last thing I just want to touch on is that also at the beginning of the year, many large Australian businesses and financial institutions are required to prepare annual sustainability reports. These reports must include mandatory climate-related financial disclosures, reflecting the growing importance of environmental considerations in business operations. So this concludes the main part of our webinar. We've got a SME legal health checklist on the screen there, so you can use that QR code to download that, which you may find helpful. You may also be interested in our upcoming event, Disputes 101, How to Navigate a Business Dispute, which is on Thursday, 13th of February, that's next week at 11 a.m. Send through your questions, and while you're doing so, I will take a minute to tell you a bit more about LegalVision's membership, but very happy for us to go through all those questions afterwards. By becoming a LegalVision member, your business will get unlimited access to our full team of over 100 specialist lawyers for all of your business as usual legal needs. Basically, it's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviews of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of your business as usual legal work. You can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal needs. To learn more about how membership or a desk extension can help you, you can request a free consultation when the survey appears at the end of the webinar. What we'll do now is we'll answer some of your questions. I can see a few have come through, some were submitted beforehand as well, but feel free to put them through now. So we'll run through these. The first one I can see here has come through. It says, how is the best way to put in a liability clause, limitation of liability clause in a contract? A good question. I sort of touched on this before. So when you are providing goods, services, software, whatever it is that you're providing, it is the key risk for you is liability, I suppose. You don't want someone suing you, essentially, as a result of the work you've done for them. So when drafting a limitation of liability clause, there's typically sort of three things I like to see in it. One would be a liability cap. So that's essentially a ceiling on the amount you can be liable for under the contract. Usually that's a number amount, or maybe it's capped to the amount of fees that your clients paid you. The second thing we want to see is a exclusion of consequential losses. Now, these are losses that stem indirectly from your provision of the services. So it might include things like a loss of profits. So if you're providing software to someone, the software goes down and they can't run their business and they rack up all these costs, you don't want to be liable for all of that. So we want to limit that. So that's called consequential loss exclusion. The last thing I'd want to see is a proportionate liability clause. So essentially a clause saying, well, to the extent that you, my customer, cause some of this liability, we're not going to be liable for that. So if they've given you incorrect information or incorrect data and they suffer some sort of loss, we can reduce your liability in that way. I suppose the other thing we also put in contracts is a force majeure clause, and these became quite the talk during COVID, but essentially making sure you're not liable for things that is essentially an act of God. So that would be things like if there's any sort of fire, flood, war, or COVID, as the case was. Tom, did you want to answer a question now?
Yeah, thanks, Lauren. So I can see another one has come through about why have IP in the holding company and not a separate sister entity? So it's a good question, and whether or not you set up a whole separate IP holding company, essentially sitting under the holding company, really comes down to the individual facts and circumstances at the time. It's usually sufficient protection to have a holding company without a separate IP entity. However, there may be other commercial reasons for having a separate IP entity, you know, if it's particularly IP heavy business, or maybe if there's going to be significant research and development that's happening, you may want to separate that out into an IP holding company. So it really comes down to exactly what the business is doing and what the most appropriate structure is. You know, and as I said at the start of the webinar, one structure may be appropriate on day one, but may not be appropriate in a year's time. So it's always possible to restructure later, and we can certainly talk you through you know, what might make sense for you at this point of the business journey, because you know, facts and circumstances always change, and so too should the business structure in adapting to that.
There's also one that's come in regarding AI, which is a really good question. So asking about AI in an age where sort of everything gets mashed together into a new design or new product. So, I mean, essentially at the moment, we're seeing a lot of language learning models, ChatGPT, Claude, Google's released one recently, Gemini. So we're seeing all these different products come out. And I suppose the concern is that they use information off the internet most of the time, and then they generate some sort of output for you, whether that be text or whether that be a photo or a picture, an image. And then if you go to use that for your clients or in your business, the concern is, well, who owns that IP? And can I actually use that? Now, it's a question that sort of comes down to, well, what service are you using and what are you paying for it? Lots of businesses or AI businesses offer different products. So it might be if you're using the free version, they're not going to make any promises to you that the AI tools that they're using are not going to infringe any third-party IP. They're not going to make any promises that if you input information into it, that they're not going to use it for developing their language model further. So in those sorts of situations, you want to be super careful, one, about the information you input, both personal information, confidential information, IP that's yours, because you don't know what's going to happen to it. And you also want to be super careful about the output, because you don't want a situation where someone pays you for a logo you've designed, you give it to them, and then a knock comes on the door from a different company saying, well, that's my logo. Why have you taken that? And they sue you. So that's sort of that. But we're also seeing lots of AI companies, designed specifically in the business world. You're paying money for them. They've put lots of protections around assuring you that they're not going to use the information you input into training their models. And they might be willing to provide more or stand behind their products more in terms of IP and saying that it's not going to infringe a third party's IP. There's also questions around ownership of things that the output. So the first thing to do is look to the terms and conditions, but I suppose it's just not been around long enough for us to have a lot of case law on what's going on there. So I think you need to sort of be careful if you're using that output and then selling it on to clients. But definitely something that we are doing a lot of at the moment, we can help with, and reviewing those terms and conditions is super important. Tom, did you want to take a question?
Yeah, absolutely. So there was another question which came through around applying for trademarks and intellectual property for a brand when everyone else is doing the same thing. So it's a good question, and particularly around the trademark process. When it comes to applying for a trademark, you apply for a trademark in a number of certain classes. I can't remember off the top of my head how many classes there are, but there are a number of them. And those classes relate to the goods or services that you're providing. And so it allows similar branding to coexist if that branding relates to a completely different product or good or service that you're providing. So if you're selling shoes and someone else is selling software, potentially those two trademarks would not conflict with each other. So even if they're quite similar, they might be allowed to coexist. So that's something our trademarks team would definitely be able to walk through with you. And again, it's why doing those searches yourself are super important, because just by seeing what else is out there before you really get started, or before you really, you really hone in on a particular branding asset that you want to use, that could save you a lot of heartache by, not going too far before it's not too late to pivot and change your branding if there is something out there that's quite similar and also relates to the products that you are actually selling. Lauren?
Thanks, Tom. A lot of IP questions coming through. There's a couple that are quite similar, so I'll try handle them together. One was on what are some of the best legal mechanisms to protect online course IP. I've also got one saying that we are a chemical company, a customer wants to conduct testing of our product. How do we maintain the results as company data? And there's another one here as well around, we're an environmental consulting firm. How can we include provisions for protecting our IP on our client's contract that they want ownership of it? And our IP is primarily industry knowledge and advice, data modeling, and our method of conducting research. So I suppose let's start off with how this is done. It's achieved through a contract. Tom mentioned before that you've got registrable IP, things like trademarks, and then we've got non-registrable IP like copyright, and this needs to be set out in the contract. Now, a starting point, if there's no contract, is that the party that creates the IP will be the owner of it, but this can be changed through a contract. So typically in a contract, you're going to set out a couple of different things. One is the party's background IP. So this is the IP that parties owned before they entered into the contract. So in the context of the online course business, you'd be wanting to be saying, well, anything in the online course, that's ours. Any improvements to the online course, we're the owner of that. All we're doing is giving you permission to use that. And in the context of the environmental consulting firm, we'd be referring to that sort of industry knowledge, advice, any sort of models you have, calculations, etc., your methods as your background IP. So these are things that, as I said, and not necessarily new IP for this specific contract. So we'll set out that you own that IP. The contract will then also address new IP, so new materials that are created in the course of this relationship. Now, perhaps not so relevant to the online course, or maybe, I guess, student assignments, etc., will create new IP. So it's going to set out who owns that new IP. So in the example of the chemical company, and we're talking about your customer wants to conduct testing of your product, how do we maintain the results as company data? You'd want the contract to set out, well, any new IP created or any sort of test results are going to be owned by us. In terms of the environmental consulting firm, a similar thing here. So the customer wants to own that IP. Sure, they can own the IP and the new materials, provided that they pay you enough money for it, and that's sort of a worthwhile business decision from you. And then we'll make sure there's those clauses in there that you can retain that other knowledge that you have, so that background IP. That one can often be a bit tricky, and we see that come up from time to time around knowledge and advice. It's difficult to say, well, that's ours, you can't go use it. Of course, people, once they learn knowledge, they can't sort of unlearn that knowledge. But we can certainly do things there within the contract to help you there. And we can also put in things like confidentiality clauses to protect any sort of particular methods that you're using. We are running out of time, but I'll let Tom answer one more.
Thank you. So last one that I want to cover, which has come through, is what protection is needed when hiring contractors and is using your own written contracts without a lawyer okay? I don't think you'll ever meet a lawyer who's going to say that a contract not drafted by a lawyer is the best way to go. That's why we exist. So it would definitely be our recommendation to have us prepare something bespoke for you to make sure it is fit for purpose. But when it comes to contractors, putting my tax hat on, it is super important to get advice when you are thinking about engaging contractors. It's as I said, when it comes to employment taxes, it's a super big focus area at the moment for the Australian Taxation Office, and separately, there's a lot going on in the Fair Work space as well when it comes to correctly classifying workers as either a contractor or an employee. You do have to work through a few tests to figure out that, basically whether on balance, is this person a genuine contractor or do they walk and talk more like an employee? And as a result, would they be considered an employee for both employment law and tax law purposes? Even if not, for things like superannuation specifically, and also state taxes like payroll tax, there are situations where contractors can be considered an employee specifically for those taxes. So, particularly around superannuation, because of that extended meaning, it does mean that contractors can be caught up in the superannuation net for businesses, and a lot of businesses don't realise that. So because superannuation is something which the ATO can impose director penalty notices over the directors for, they can be pretty hefty consequences for getting it wrong. So definitely would recommend reaching out to us if you do have contractors, because there can be a lot of nuance and risk in using contractors, particularly where they are doing things which look a lot like what employees may do. But yeah, as Lauren said, that's all the time we do have for today. If we haven't gotten to your question, we're very sorry. So please submit your details in the surveys that pops up at the end for assistance with any questions that you have that we weren't able to get to today, and to also to learn more about how our membership can assist you. While this is a free webinar, we do value your feedback, so please complete the 30-second survey which pops up at the end of the webinar. Thank you so much for joining us today.